Hello and welcome to Caucasian Journal video interviews. It is a great pleasure for us to welcome Jens-Hinrich BINDER, Professor of Law at Eberhard Karl's University in Tübingen, Germany, where he holds a chair in private law, commercial and corporate law. It is not only an honor for us, but also a rare opportunity to talk about some very important aspects of EU integration. I mean the European financial regulation, especially what is directly relevant to the general public. For EU candidate countries, there is a simple question which might be a good start for our discussion. Will my life savings be better protected after we enter the European Union?
Well, that depends on how your life savings are organized, I would say. If you have your savings in a bank account, traditional banking savings account, that might be the case depending on the quality of bank regulation and other elements of what we call the bank safety net. That is those arrangements that try to protect bank savings right now. And if European law adds to the quality by introducing mandatory European financial regulations, then there might be a benefit in terms of greater safety and higher levels of protection. So that very much depends, of course, of the state of affairs right now. But in principle, I think it is fair to say that European law, especially after the global financial crisis back in 2007, from 2007 to 2009, has reached a rather high level of protective measures and preventive regulations, which can indeed be argued to have made the whole system safer and thus also have protected individual savings.
I see. We know that Deposit Guarantee Scheme, or DGS, protects all bank deposits up to 100,000 euro. Can you perhaps tell us more about these mechanisms and its effectiveness?
Yes, I think the basic principle is quite simple in that a deposit guarantee scheme operates to some extent like an insurance company. And in this case, this is a scheme, an arrangement usually run by either a state organization or an organization set up by the banks that essentially insures deposits that are held by the participating banks. So if you are a bank and if you have 1,000 customers with savings accounts in your bank, then as a member of a deposit guarantee scheme, you need to take out insurance over these savings accounts. That is, you have to pay the DGS, the deposit guarantee scheme, a certain amount of money. And in the event of a failure, if I, as the bank, become insolvent, then the savers whose money is recorded in those accounts will receive a payment in the amount of deposits. As you rightly mentioned, in Europe, this is guaranteed for deposits up to 100,000 euros per depositor per bank. So that's the basic principle. And on the grounds of the European Deposit Guarantee Scheme Directive, or Deposit Guarantee Directive, as it is often referred to, which was enacted in a revised form in 2014, there are several rules and arrangements in place whereby each member state has to guarantee that all deposits held within their territory are protected by at least one such deposit guarantee scheme. So each member state has to establish a deposit guarantee scheme that conforms with the requirements stipulated in that directive, so that all banks have to participate and all depositors are guaranteed that sort of level of protection in the event of a bank failure.
Was it difficult to introduce the DGS? And is it how unique is it? Are there any comparable models in other regions? Not single countries, but regions.
Well, in principle, the existence of a deposit guarantee scheme, I would say, has come to be regarded as an essential part of what we call the bank safety net. So in order to protect both economies and individuals against the risk of financial failure, jurisdictions worldwide, essentially, for a lot of time, for decades, have developed certain components, regulatory components that are supposed to either prevent a bank crisis or indeed, if a bank failure occurs, protect individuals and the system against the outcome of that failure. And in the case of deposit guarantee schemes, it is fair to say that several jurisdictions have for decades established and maintained deposit guarantee schemes. So for instance, if you take the case of Germany, there the first deposit guarantee scheme has been established in the times after World War II. So a lot of jurisdictions have held those principles and those systems in place. And nowadays, I think it is fair to say that they are almost commonplace. So there's a very strong association called the International Association of Deposit Insurers, which has lobbied for some time now for the introduction of deposit guarantee schemes. And to my knowledge, they can be found pretty much everywhere in most mature economies. That said, it is important to bear in mind that the European system is particularly strong, I would say, for a couple of reasons. First, because it is prescribed in a piece of legislation that applies mandatorily across the European Union. So essentially, the member states have to provide the same high level of protection. You referred to the 100,000 euro level, which is very high, and in many economies captures most of the savings held by private individuals, so that depositors do not really have to fear that if one individual bank fails at a time, which is the usual state of affairs in normal times, that is outside systemic financial crisis, then the system will be strong enough to pay immediately. And this is coupled with also quite restrictive mandatory payout provisions, whereby the repayment to the individual depositor has to be made within 7 working days from the date on which the administrative authority that is responsible for supervising the bank has declared the bank to be failing. So that, taken together, I would say, is a rather strong scheme. In that, it is probably, if not unique, then at least one of the strongest regimes you can find.
When a new country joins the European Union, does the DGS apply to its banks automatically?
Well, member states and new member states are required to transpose, that is, to apply the European legal framework as a whole, the acquis communautaire, as this is called, so the whole body of laws and regulations that has been adopted by the European Union. And this is so also in the area of financial law. And as a consequence, any member state that wishes, or any jurisdiction that wishes to become a member state of the European Union, indeed has to take legislative measures to transpose the DGS directive. So yes, the answer is that indeed it has to be applied. It does not apply automatically because the DGS directive is not a piece of legislation that essentially implements itself in each member state. It has to be transposed by member state legislation, as every other directive as well. So there are two types of EU legislative acts. One is the directive, which has to be transposed. That is where each member state has to enact legislation on its own to make the law work within its territory. And the other alternative is the regulation, which applies directly in all member states. And this part of EU financial legislation has been adopted in the form of a directive and thus does not apply automatically. But every acceding member state has to adopt relevant legislation, has to demonstrate to the Union that it has relevant legislation in place. And indeed, if it fails to adopt relevant legislation, or if the national legislation adopted to transpose that directive is insufficient in that it does not guarantee the required level of protection to individual citizens, then the member state itself is liable in damages. So it has to repay basically the depositors in this case for the losses. There is one famous case that was brought before the European Court of Justice many years ago that originated from Germany, where Germany had failed to transpose the initial version of the 1994 directive, the DGS directive of 1994, and where the country was held to be liable for damages for that. So depositors who had not received what they would have received had the directive been adopted correctly would have received damages for that by the member state.
I see. Can the strict European financial regulations lead to the closure of smaller or weaker banks in the new member states? Or can they lead to increase in the costs of banking services for customers? Or does more competition lead to lower prices?
I think that very much depends on the circumstances of the individual banking system. It's very difficult to formulate a general abstract answer to those questions. There is no general rule under European law that small banks have to go out of the market, nor is there an automatic principle that weak banks will automatically leave the market. However, European law comes with a rather complex and very detailed set of what we call prudential regulations of banks, that is regulations that apply to the financial condition of the banks, that is to own funds, the level of own funds in the bank, own capital, also to the liquidity position of a bank. They also apply to the governance of banks. So they prescribe a very broad range of rather restrictive corporate governance-oriented regulations. And they provide for sanctions if those conditions are violated, if those conditions are not met by the individual banks. So there is a principle that each member state has to supervise its banks. The largest banks in member states are supervised not by the national authorities, but by the European Central Bank, if and to the extent the member state is member of the Eurozone. So in the Eurozone, you have the European Central Bank as the single supervisory authority. And of course, if there is a problem with a weak bank, that is a bank that is on the brink of failure, that is, as we call that, failing or likely to fail on the grounds of parameters that are specified in law, then the bank will be closed and wound up, that is liquidated or restructured by the authorities. And of course, there is a certain degree of pressure on the member states to make this happen. And member states can also be sanctioned if they do not supervise their banks correctly and according to the letter. And ultimately, that means that by virtue of European law, failing banks tend to be pushed out of the market or tend to be restructured. There are various means for that, very complex legislations, both at the European level and the national levels. And usually this is something that will be the case. So there will be a cleanup of the national banking system. Now, what does that mean in terms of banking conditions for the individual customers? Can that lead to an increase in the cost of banking services or to the opposite? Again, this is something that very much depends on the situation in the member states. There are member states with highly diversified banks. For instance, Germany has several thousands of banks of different legal forms and that are owned in different ways by different players. That is, you have banks listed on the stock exchange. You also have banks that are owned by municipalities, and you have cooperative banks that are owned by, for instance, normal people and small enterprises. And here you have a rather diversified system. In other member states, you have highly concentrated banking systems. Very often, what we have seen as a result of structural crisis in some member states is a consolidated banking systems with very few very large banks, which then, if these states participate in the Eurozone, are supervised by the ECB. And to my knowledge, the level of costs that are tied to bank services is very different across member states. There are efficient systems, other systems which are less efficient. I suppose that there are, of course, causal links between the regulatory side on the one hand, and the cost that have to be incurred by using banking services. But the direct link is rather blurred, and that also very much has to be tied back to the individual structure of the banking system. So basically, there is no clear-cut answer to these questions.
I see. From your viewpoint, besides the DGS, what other European financial regulations are most important for the customers in the new member states?
Right. I think here you have to distinguish between two types of financial, I would say, pieces of legislation, directives and regulations in the technical sense. The one are instruments that directly govern the relationship between banks and their customers. There are essentially two very important areas where this is the case. One is consumer credit, including mortgage credit, that is loans guaranteed by mortgages on residential property, and the other is payment services. So you have a very complex set of European financial law instruments that govern payment services, which is currently in the process of being reformed. And you also have two very important legal instruments in the field of consumer credit. That is the Consumer Credit Directive, which basically lays down very complex protective rules for people taking out bank loans as consumers, say to buy a new car or to finance holidays or whatever. And there are very, very restrictive provisions that try and make sure that banks lend responsibly and that consumers are protected against aggressive and abusive lending practices. And then there is the Mortgage Credit Directive, which tops this regime up with tailor-made provisions for lending contracts that involve the provision of mortgages, because obviously for many people, their domestic real estate, their house is the most important asset. And this directive tries to make sure that there are adequate levels of protection for house owners, owners of residential property, which is used as collateral for a loan. So this is the range of tools that are focused directly on the relationship between banks and consumers, or banks and customers generally. And then you have, of course, parts of the legal safety net for banks that work indirectly, that apply between states and banks, but at the same time protect also the individual bank customer by making the bank more safe and less risky. And here you have essentially two large complex pieces of legislation, one directive and one regulation, the CRD, which stands for Capital Requirements Directive, and the CRR, which stands for Bank Capital Requirements Regulation. And these instruments taken together are basically the core of the financial safety net for banks, in that these do contain both the financial and the governance related requirements that are designed to make banks safer. So the essential legal framework for the regulation of banks, the prudential regulation of banks, have to be found in these instruments. And these are the basis for the supervision, the ongoing supervision of banks. They also lay down the conditions that must be met if banks want to be licensed as banks in the first place. And of course, while this does not directly apply as between the individual bank customer and the bank, it does help the customers enormously because it makes the whole banking system safer. And I would say these are probably, in total terms, that is macroeconomically, if you want, more important even than the instruments I mentioned before, that is those instruments that apply directly between banks and their customers.
Simply put, what changes, good or bad, can the public expect in the financial sector after entering the European Union?
Well, this is difficult to predict, of course, and do not, make me responsible for wrongful predictions in this regard. But I would say that in general, it is fair to say that with the accession of new member states, those new member states accede not just to the internal market as such, but they also accede in this area to state-of-the-art set of financial regulation in the widest sense, which involves not just banking services, but also investment firms, insurance companies, insurance regulation, and other areas of financial law that is broadly consistent with all the international standards are in place, and that essentially tries to make sure that the financial system as a whole, including also the banking system in the narrow sense, is safer. I think, generally speaking, it's fair to say that European banking systems are safer than most international peers because they tend to be well regulated, they tend to be well supervised. There are mechanisms in place to make sure that financial fraud does not work to the detriment of consumers and so forth. So in order to understand that, I think it is important to know that several European jurisdictions have seen lots of financial crises, lots of failures, also lots of financial fraud over decades since the foundation of the European Economic Community. And since the late 1970s, European law has worked in order to remedy those problems by reinforcing regulation and supervision and trying to make sure that the level of protection afforded to consumers is high in comparison to other standards. And this is something I think acceding countries can look forward to. Well, the downside, of course, associated with that is higher levels of cost. So very likely the cost, the regulatory burden that is going to be seen in acceding countries is higher than previously. They have to adjust, they have to implement all those laws and regulations, which increases the need for appropriate legal advice, and that comes with costs which are ultimately borne by the consumer. Hopefully, there is also efficiency gains associated with that, which should offset that in due course. So do look at this not simply through the lens of banking regulation, but take it as part of a far broader picture, I would think.
Thank you very much for this excellent interview. You are always welcome at Caucasian Journal.
Thank you very much
Thank
indeed
you.
for your interest again. And if you have any more questions, feel free to reach out. Thank you.
We cover what matters. Caucasian Journal.